We've been unable to resolve your case, therefore we need to proceed to trial, which is the fourth step in the process. The first thing that would occur is that we would have another meeting with you, this one probably in my office, where we could discuss the strategy of the trial and the process of the trial. I would explain to you about opening statements. I would explain to you about how direct examination works, and then cross-examination, then how we would put on our witnesses, and then I would talk to you about closing arguments and the burden of proof so that you understood the process. But then I would prepare you personally for the trial, because in some cases you may have to testify. So what I would do is I'd probably role play a little bit. I would set out a chair, tell you it was the jury, where the jury was, and this was the witness chair. I'd have you sit in there, and then I would play the prosecutor, and I would attack you via questions. And then afterwards, I would critique your performance. I would say, look, you argued too much with him. One of the biggest things I tell clients when they're on the stand is not to argue with the prosecutor. For example, if you're caught in a lie, just own it. For example, if you said that I was coming home and I was wearing a red t-shirt and the pictures show that you were in a blue t-shirt, you don't argue with the prosecutor and saying that you just recently changed and you forgot. You just say, yes, I said red, it was really blue, I made a mistake, I'm sorry, that's what I thought it was, and you own the lie and you move forward. I might tell you you're being too defensive, or that you're not looking where the jury box is, so that you're not looking the jurors in the eye. And I would go over this and we would role play it, and maybe we would do it a second time so that you feel more comfortable, because unlike myself and the prosecutor and the judge, this is probably your first time in the courtroom and you're going to be nervous. So I want to make sure that you don't appear too nervous and that you're familiar with the process. So we would do this role playing so that you would be prepared for the trial. After you leave my office, there's a lot of work that I would need to do to prepare for your trial. I would research the law, prepare any motions in limine. Motions in limine are motions that the judge hears pre-trial as compared to the motions that were heard earlier, like motions to suppress evidence. A motion in limine may be to exclude witnesses or to sever charges, or things of that nature. So I would prepare all the law that was necessary to handle your case. And then as your trial date appeared closer, we would meet again, make sure you were prepared for the time and place and location, and understood what was expected of you, family members, and your witnesses. On the day of trial, we would answer ready, and we would be assigned to a judge. And then we would go through the steps of the trial as I explained them to you. The opening motions in limine, opening statements, direct evidence, cross-examination, our witnesses, cross-examination of our witnesses, and then closing argument to the jury. And when all that was done, the jury would then deliberate, and when they came back, their decision would be final. They would come back guilty or not guilty, or that they're hung. And something that most people aren't aware of is that it has to be unanimous, meaning in order to be guilty, all 12 jurors have to say you are guilty. Likewise, to be innocent, all 12 actually have to say you're innocent. So if it's any type of split, the jury would be hung, and then you would have to do a retrial of the case. Depending on the verdict, guilty, then we would have to move on to further stages in the proceedings. On the other hand, if it comes back not guilty, then the case would be over at that point.